We're live. Yay!
Okay, the Kenmore Business Center Natural Resources Energy, and it is Wednesday, February 25th. And we are starting with S224, continuing to have a committee discussion, hoping to get through as much of this bill as we can, closing it out. So I've been working with Councilman Grady. The table, and just as an FYI to the committee, I did yesterday chat with folks in transportation about the DMV portion of this, and they're gonna have a conversation about what they would like to do with that. And yes, and they the chair just expressed that it's basically the sooner we can get this done, the better, which is also my sentiment. So, in any case, I think we're up. Well, maybe there's changes that you would like to, that you could walk us through on sections 1 through 6. Otherwise, then I think it's.
There are changes.
Yes, section 7 that we can start in on.
Right.
But I think talking through the changes that we made last time would be good.
Sure.
Yeah.
So on page 2 in the definitions for use of waters, you wanted definitions of aquatic nuisance inspection station, boat watching unit, and decontamination service provider. So some of the language that was provided from different advocates kind of overlapped those definitions. I tried to make them distinguishable. So an aquatic nuisance inspection station is at or in proximity to an access to a lake or other water. It's staffed by volunteers. It utilizes minimal space to operate portable equipment, such as boat watching units. It educates about aquatic nuisance species and it conducts inspection of vessels for aquatic nuisance species, and it removes and disposes of aquatic nuisance species found in the vessel. So that's volunteer, transportable or temporary equipment, education, inspection, removal. Boat washing unit is the portable equipment capable of cleaning the exterior with pressurized water, but not hot water. So that's what an inspection station is going to use. But a decontamination service provider, I looked at definitions from around the country. The site at or in proximity to an access to a lake or other water, owned or operated by a private entity or state. So it's not volunteers, private entity or the state. It's designed to remove or prevent the spread of aquatic nuisance species through the use of high pressure and hot water over 140 degrees Fahrenheit. So it's going to have access to hot water. And it's located in a way to collect runoff or to prevent runoff of surface waters for well.
Yes, so much about that, the at or in proximity to. If it was in a like boat dealers, those aren't always right near lakes.
That's a good point. At or in proximity to an access to a lake or water, or at a vessel service station or something like that.
Yeah, I'm just thinking there's, I don't know, there's a boat dealer, I think in Ferrisburg that maybe could be considered near the lake, but it's several miles from the lake. I don't know.
You're thinking just specifically for the definition of decontamination
service provider.
The boat washing.
Yeah, the boat washing usually is right like in the parking lot or someplace near the lake, but the decon stations, which are basically like car washes, more of a boat wash, you know, they're they're bigger.
I think I was thinking the aquatic nuisance is also says in proximity, but that's like it's either in the parking lot or just outside, or it's near.
I said proximity because there was testimony that they're not necessarily in the access area. They could be up the road that is not owned by the department and located there.
Right.
So then it's you have to account for that as well.
Right. So potentially adding to 23. Or,
To proximity to an access to a lake or water at or in proximity or at, I would just say a private business that conducts decontamination services, so it could.
Yeah.
That work?
yeah.
I think so.
Mhm. Sounds good to you.
Well, do you see what you think? Because they wanna make sure they have a catchment area. You know, I know, Woodard Marine has a decon apparatus.
Right, because that's the last subdivision here, I put in, it has to be located in a way to keep runoff. Or to prevent runoff to surface waters as well.
So that's covered.
That's the,
Mhm.
So, we're just gonna put a whole limit after the word site on line 5.
I think I'm gonna have to rework it a little bit because. Because I just need to rework it, I have to look at it and see how. I can. You know,
That's good.
maybe.
Draft on the
I'm
fly.
blind.
Fair.
So the next change is on page 8. And this is in that definition of weight code in title 23, the motor vehicles, you wanted to cross-reference back to the definition. In 1422, which you just looked at, it was in that same section you just looked at.
Great.
And then the next section, next change, page 11. And this is in the submission from DMV to A&R of the information about lake flow designation and home lake designation. It didn't say annually before, and so now it says annually. And then that really brings you to page 12. And this you didn't actually review in your last walkthrough because you had requested it like 2 walkthroughs ago. And it was the public outreach regarding wakewood use and decontamination. A&R and DMV provide education and outreach to the public regarding the requirements of the 1420B. The wakewood shall only operate on the lake authorized for wakewood use and shall only operate if the lake is designated on the wakewood's current registration as the wakewood swim lake or approved by the owner or operator of wakewood decontamination. At an A&R service provider. Fill the education and outreach, A&R post signage regarding the requirements for operation of wakefoods at all state fishing and access areas and other new public means of access to lakes and ponds. A&R shall include a notification regarding the requirements for operation of wakefoods and accompanying fishing license applications on the agency website or in the Department of Fish and Wildlife printed materials. And then DMV shall include a notification regarding the requirements for operation of wakeboats on the DMV website and with materials for the registration of vessels where such materials are available. I will note from my experience with Dynamo, the signage costs money and that'll put you into an appropriate discussion.
Mhm. And the signage is page 12, 16 through line 16 through 18.
Yeah. Notifications on websites, amendments to application materials or publications generally don't cost anything because they're done every year.
Mhm.
But if you're putting signage up in areas, it's really costs.
Yeah,
Yeah.
okay, yes.
Going to the first paragraph, the home lake part, and then on line 12, or upon approved by the owner or operator of the lake, decontamination of the lake, though. Doesn't say when that has to happen.
I mean,
Since being moved from a body of water. Or something like that.
I do think that part of the discussion earlier about when you want to do that, because there's people who see it.
Voted definition.
1424, no, it's that prior to entering a Vermont lake, other than Wakefield's home lake, prior to re-entering a home lake after use of the Wakefield, the person who owns or controls the Wakefield shall be decontaminated. So do you want that added in there?
I mean, I can picture having a reference like,
According to.
yeah, in reference to.
Yeah.
How,
Yes, yeah.
how, currently the agency does a lot of outreach about fishing laws and lake usage, et cetera. That was soon, I actually found that they do, so. Wouldn't most of this just be like adding to what they already do?
For their annual publications and their website material, would just be added to this, and I don't think it will have cost.
It's
Well-
just the actual physical side.
Physical sign.
Okay, I mean, what if we added something like? Essentially, like, if sufficient funds exist, they would, or when updating signs for other purposes, they would add it, or something like that, so that it's. Not like they have to go buy new signs in July, just for this, if they're to update their signs for other purposes, they would add something about Bigfoots. I don't know.
I mean, I think that's a valid alternative.
Okay, cause I think they're not, I don't know
Yeah.
that we wanna get into a appropriations fight about this.
Yes, I think that's fair. Sort of as, how do I,
Okay,
you have enough information
I
to
do.
frame something like that, okay. Okay,
then there is one other change that was in the previous two markups ago, and this was. I believe this is a suggestion from Barry to whom. That page 16 line 4 through 8. The Commissioner of Fish and Wildlife in coordination with the Commissioner of Environment and Conservation. To collaborate with any local or state entity that proposes to establish, operate, and maintain an aquatic nuisance inspection station. Or decontamination service provider at any Department of Fish and Wildlife Control access area. So that's what Barry suggested, but I'm not sure if you want the decontamination service provider at the access area.
yeah. Mhm. Yeah, I would agree, because it could be elsewhere.
Yeah, and then we'll just get into a big,
Mhm.
it's not a good place for those big things.
Page 16 line 4 through 8.
So a lot of those access areas, the slope isn't adequate, they actually go towards the lake, so.
Mhm.
Okay, so those are the changes, but the last walkthrough, I think you got to. Either section 7 or section 7 really. And this would just. The judge zone A suggestion to bring underneath the Title 23 potential violations that go to the Judicial Bureau. The citation of page 11, line 16, 1424B.
Sorry, I think I've lost you where you were.
Page 11,
Oh, page 11. Okay.
section 7. Line 16. This was
Oh, yes,
Judge Zoney's suggestion about making clear that 1424B, the decontamination and inspection requirements. Are also a potential DMV violation or DMV enforceable violation under Title 23. And these go to the judicial bureau.
right. Okay,
So that, I think, you just did section 8. So you can go to page 13, which is line 8, which is section 9, and now you're into the discussion about the use of fish and wildlife access areas.
Wait, can we stop? Just something sure. Oh, this paragraph K on page 11, I was just thinking, I have a note that says starting in 2028 and annually thereafter. Is that,
I did have the annually thereafter,
I don't know why I wrote 2028, but
that's because DMV said that that's when they could do it, I mean, look, no, I do need to add, that's
starting,
2028, yeah.
no,
I might do that in the implementation section,
okay.
Oh, like an effective date.
yeah. So that we don't have you don't have an obsolete date in 2 years.
Right, okay.
Okay. So page 13, line 8, section 9. These are the access, banning area, rules authority, it's the statutory authority you gave the boards. The first change is changing the rulemaking authority from the board to the commissioner. And that's for the accountability. The board is largely non-accountable, but the commissioner is accountable. Commissioner is appointed, commissioner is subject to the budget, etc. That's a policy decision as well, whether or not you want to.
Where are you?
Page 13, line 10.
I find this, that as individually as a change. For the, you have thoughts on that? Okay.
It's fine. Okay. So then you can go to page 15.
Michael, before we do, on line 16. Is there a potential conflict when it says the rule shall not give authorization to launch justice law that should remind? And the fact that the lake boat can't cut it unless it's been contaminated,
Which line are you on?
16 and 17 on page 13.
Okay.
I can clarify that.
Yeah, I think that, I agree, I think it's a little. Maybe. And like, subject to this requirement.
And that's. There are provisions under federal law that the access areas are funded with the federal. Federal funds have to provide for motor boat access, but you can have reasonable requirements for entry and exit, such as registration, validation, et cetera. So I think I can fill that in. So moving then on to page 15, lines 3 through 5. This is where there's already a distinction or requirement that the board allow for posting of the product nuisance signs in an access area. So this is going to be the commissioner that is doing it. And it says mandate instead of shall allow, which shall post. But considering your previous change about appropriations, I think I'm gonna have to mark that up a little bit and maybe go back to shall allow. Does that make sense for everyone?
Would you still have it, the commissioner shall allow?
Commissioner, yeah,
Okay. Or,
the commissioner shall allow the commissioner of environment and conservation.
oh, it's the commissioner of,
Right, it's the commissioner of environment and conservation when it's a product nuisance program.
okay. Two commissioners.
Moving on,
Mhm.
page 15, line 6 through 10. This is upon issuance of a permit by the commissioner, a fishing access area may be used by an approved aquatic nuisance inspection station in order to allow for decontamination of wake boats. Oh, I should say cleaning. Inspection under 1424. For inspection of vessels entering lakes as required under section 424. So this is the difference, right? This is not what the bills introduced did. The bills introduced said that aquatic nuisance inspection station was an allowed use. Now, it was far down on the priority of uses, but it was allowed. It didn't need a permit from the commissioner in order to operate. This now requires a permit. This is largely the department's proposal. And so that's a policy decision. Now, I think what you need to weigh is that the advocates want it to be an allowed use, but they want it to be high up in the priority of uses. And that's problematic because the current federal rule says that the access areas need to be used for their authorized uses, and the authorized use is in the grant. It then goes on to say that the state can allow for secondary use of recreational uses that are not authorized in the grant, but those secondary uses can interfere with the authorized use. So if you make the aquatic nuisance inspection station number 1, as some of the advocates want it to be, or number 3, as others do, you're likely going to have an interference with one of the authorized uses for the access area. If you put it down as number 9, you're not likely going to have that interference. And if you do, then they have to resolve that interference, that conflict. And the aquatic nuisance inspection station would have to be removed until the conflict is resolved. Now, that doesn't necessarily address the department's point of view that they shouldn't just be allowed everywhere in every access area, and there should be review of the site conditions before an inspection station is located in an access area. And so that's why they're looking for the permit, because they want to be able to do site evaluation to determine if an inspection station should go in the access area, and if so, where. And they've given, I think they've given you examples of where it's not appropriate or where they would say, I think when I talked to them, they gave the example of Shadow Lake and Glover, and I don't know if you've ever been there, but on the, I guess it's the south end or the east end, there's a beach and a parking area, and the inspection station is sited set back from the beach so that there isn't runoff into the water, and it's portable, so it can move if there's a conflict. And so that's the kind of thing they're looking for, instead of just the default allowed use. And that's a policy decision.
Yes.
This section only applies to decontamination of lake boats.
No, so this is going to apply to inspection stations. Remember, you defined what an aquatic nuisance inspection station is.
Yeah.
And it's not, and I acknowledge page 15, line 8, that word decontamination.
And lake boats.
And wake boats should probably be gone.
Okay. Okay,
Because this is just for any of those inspection things for any boats.
okay.
Is this in the section? Okay, it is, okay. Do you know how many fishing access areas there are? I'm looking, oh, there's a map. This is what I asked for, is a map. That's what I'm looking for. Oh,
So this is there's some policy here.
Yes. So one question that I have is, because if it goes in the list, then and there's no conflict, then someone could just set up a inspection station. But presumably, it would still have to meet all of the criteria of the definition, right? Like that it couldn't just be set up in a way that the runoff goes right into the lake, etc.
Well, right now, the aquatic nuisance inspection station definition doesn't have that
For that.
criteria, but I think you can add that.
Mhm.
You can be cited in a way that it doesn't allow for run up into a water or wetland.
Mhm. Right. Yes,
I mean, just to put it out there, if department doesn't love these things,
Mhm.
it could be not a lot of permits get issued,
Mhm.
and we'd be worse off than we are now.
Mhm. It might be more of a pain. Curious for the thoughts of the committee as to what if you have any other questions about this, or if you have any preference for, because it seems like we have this choice to make, right? Like either we put it in the list and we can talk about where in the list it goes, or we go with a permitted use.
I think we should put it as high in the list as we can make it go. That it will not.
That will not make it.
that was how the bill was introduced essentially. Yes.
Except it was the lowest.
Yeah, it was at the
It
bottom.
was the lowest, okay.
Yeah.
So we make it number 4. But no,
I mean, you can see the priority uses. It's on page 18. And so. Angling, ice fishing, launching of any vessel for fishing is one. Launching of inboard and outboard motors engaging in any activity is is 2, and that's actually related to federal law. Trapping, hunting, and parking of vehicles is 3. Non-motorized vessels not used for commercial purposes and parking is 4. And so you arguably could put it at 4, but 5 is ATVs and snowmobiles used for fishing. So if you put it above 5, you might be creating an interference with an access area that was issued a grant for fishing and for access for fishing. Permitted special uses, I think you could put it there because that's where I put it.
So it could become.
You could put it above 4.6 at 4.5. Arguably, you could put it at 4.4, but I think that might create a conflict with 4.5. Maybe you move ATVs for fishing up to 4.4. I mean, there's that kind of discussion.
It does make some sense to me to move 4.5, the ATVs and snowmobiles used for ice fishing up, since that has to do with the the purposes of the access point. But I would also hate to make that change without also consulting with them. Yes.
It seems like the ATVs for ice fishing and snowmobiles could actually be combined with number 1. Because those are,
That's valid.
yeah, that would make it cleaner.
That sounds fine to me. If we,
I want to talk to the department about that.
Yeah.
They think there's any grant where it was just the granting for the access by vessels instead of just access to core fishing.
Well, I wonder if we combine the ATVs and snowmobiles with one, if that creates a conflict between one and two.
I don't think so, because remember, the authorized purpose of most of these in the original grant and in the maintenance grants is usually access for fishing,
Right.
hunting, and outdoor
Mhm.
boats. I think you're probably gonna be okay.
Mhm. Okay. Just to go around for thoughts on what the preference is, do we add it to the list? Do we make it a permanent use? Senator Back, do you have any thoughts on this? If not, that's okay. but-
Permanent use.
Okay. As opposed to putting it in the list.
I don't know, I'm not an expert.
Okay. We can talk about it.
I'm thinking back to the argument I heard the other day for the list and. List, put it on the list. List. It just, I've heard it so many different ways from so many different sides.
Yeah, fair enough. Senator Hardy, any thoughts?
I'm sort of with Senator Beck, I'm kind of going back and forth, but I think that I think if everyone is comfortable with putting on the list, I'm fine with that.
Great. And Senator Williams.
I think that. ATVs and snowmobiles would only be an issue during the winter time, number one.
Mhm.
They already have that. I wonder if we could divide that up into winter and summer,
Hmm.
because. A lot of different uses for ice fishing that wouldn't be very back. But I think probably it could be a catch-all for their use. I think I agree with that.
So you'd rather put it in the permitted use as opposed to putting it in the prioritized list?
Right.
Okay. Whew. Less clear. So my sense right now for myself is to put it in the list, but as low as is reasonable.
Right, sorry, wait a
Or I'm sorry, as high as, thank you, yeah, that's a better way to say it. As low as it needs to be, as high as it can be. I think is where I'm falling right now, though I will also say that this is one that I feel torn about and I could argue it both ways.
When the bill was introduced, there was language about if there's a conflict, then
That's,
is that still in there?
yeah, it's on, it's actually in the rule. I mean, in the statute, not in the rule, it's on page 15. So any use of an access area by its police inspection station shall comply with the requirements of 50 CFR Part 80. And consistent with the federal regulation, if an inspection station interferes with the authorized use, the product nuisance inspection station shall relocate or modify its activities until the conflict is remediated.
Got it.
This can also be something that if this is where we're landing on list, which is where it's, seems like where we are generally. I mean, this is also something we can flag for the House to say, take more testimony from this. This is a tricky one.
It says if it would require a permit, there will be fewer of them.
Okay. Just to check, if we put it in the list, everybody could live with that? Okay. Okay, so I think we have clarity. Or I should ask you as a question, do you feel like you have clarity at this point? Okay.
I do. I'll give you some options for the ATVs as Senator Williams was saying should it be winter, not summer.
Yeah.
etc.
That's a good call.
I'll give you a couple of options for that.
Okay, thank you.
I have to say, you guys, you should look at if you haven't already, the Department of Fish and Wildlife website is actually really, really good at this, and they have a map, and they have the whole rule laid out with like a FAQ and everything, so and they have a boat safety handbook.
Oh my gosh.
Yeah, I mean, like a whole bunch of stuff in there, so it's quite good.
If you're on the website right now,
Yeah.
would it be easy enough for you to just grab that link and email it to us?
Oh, yeah, of course.
That'd be great. So I would love to make this.
So we were gonna, before, I don't wanna interrupt the train of thought right now.
That's okay. No.
We were gonna come up with a definition of decontamination. So-
Yes, I think we.
And I did meet with, Fish and Wildlife Access guy yesterday and DEC Lakes and Ponds people.
Yeah.
And they do have 2 decontamination sites,
Okay,
and they have a definition,
okay,
and a requirement for, power and water and they have a map, but unfortunately, the only decom sites right now, one is a low capacity, another high capacity,
mm-hmm,
they're on Lake Champlain.
mm-hmm,
So if we're gonna require people to go to a decom
Yeah.
site, you only 2 that are actually authorized for Lake Champlain.
mm-hmm,
So
mm-hmm.
they agree that they'd like to consider maybe having a portable one.
Yeah,
And having some sites along throughout the state where they can decontaminate, but right now it's not in the cars.
right, right, yeah. Well, it also seems to me that as there is more demand for it,
Right.
that hopefully other folks will pick it up. So, but fair enough, and there is on page 3 definition of decontamination service provider,
Mhm.
so if you have thoughts on,
And if you
What
think
that
there
would look like.
needs to be anything added, be consistent with the department's definition, I'd appreciate seeing that. I also think you have the opportunity to phase in decontamination. And to have the department over the first 6 months approve decontamination
mhm,
service areas and then go to the prohibition
mhm.
after 6 months. Or
So
something like that.
that actually makes some sense to me, because when we talk about an approved decontamination station, that is a night, so I think it's a good idea, but what is the process for getting approved as a decontamination station?
Right now, there isn't an official process. You can put in language that says on a decontamination service provider shall be approved. On a form provided by the commissioner or something like.
Mm-hmm. I would like to add something like that. Does that sound reasonable to others? Okay. Okay,
And then 6 months, they approve, and then after 6 months, the decontamination requirement goes and built up.
I think that I think is what's realistic. I realize that puts us past this summer. For that being an effective policy,
Right.
but I think that's, for this to be functional, I think that's probably what's realistic.
Okay.
And where are you putting that in the bill?
I'm gonna put it in 1424B, the way boats use for waters.
And what page is that on? Sorry.
That's on 3 or 4.
Oh,
3 and 5.
Oh, yeah.
Because that's where the requirements for decontamination, proof of decontamination. That's it, so that's where I have the
yeah, that makes sense.
agency for this, the inspections service provider.
Okay,
Okay. So that now takes you really almost page 22.
Did we end up on the list? Is that what we
I
said?
think we
Okay. Okay.
on the list,
All
yeah,
right.
as high as it can be.
Page 22, this is where fishing tournaments are. And the first provision here in section 11 is lines 10 to 20. If the department receives an application for a fishing tournament that serves as a municipality's public drinking water source, the municipality owns or controls all the land surrounding it, the department notifies the municipality of the application. Legislative body of the municipality shall review and vote to approve or disapprove the application at its next regularly scheduled meetings. Department shall issue the permit only if the legislative body of the municipality approves use of the water for the tournament. Department shall not issue a permit if the legislative body did not approve the tournament.
Okay. Thoughts on this one?
No, no.
I know, yeah,
I mean,
yeah,
you know, if you're talking about fishing. They're almost better off to separate them in the winter and summer. I
Mhm.
don't know if they actually have fishing tournaments on this reservoir during the summertime. But if you have to wait for a permit from the Fish and Wildlife, and then it goes to the municipality and wait until their next meeting. The date is already gone and they can't count on having lights to do the dirt. I think that just makes it, so we're not gonna have dirt.
Other thoughts?
I'm just looking at the other language because I was hoping that we could. I don't know what information is required when somebody applies for a fishing derby tournament permit. So I've never done it myself. Well, what information do they have to provide the permit, you know?
They have to provide the organizer name, the site, the date. I think there's supposed to be like a general scope, like number of participants. And I think that's basically it.
What they're fishing for, maybe?
I don't know if it's on there.
Cause I'm,
Don't they have to have liability insurance too? Don't they have to, that the organizer is required to have liability, insurance like that. So,
because I was just thinking, this is a pretty blunt instrument, and I don't think the select board or city council would have much information to make the decision on. With, you know, it would just be a, well, I like this or I don't like this kind of decision, which is hard to make. So I'm just wondering if we might want to first try something like if you're going to apply to do a fishing derby on a drinking water source, you have to provide additional information. You have to have additional sort of precautions. And there needs to be communication or notification to the municipality. There needs to be requirements that X, Y, and Z happens. I don't know exactly what X, Y, and Z are at the moment, but I just feel like there could be an interim where it's not like we're saying no, or giving the decision to the locals, but that we're getting the bar is higher if you want to do a fishing tournament on a drinking water source.
So we'd like to hear the information here.
It's in 1 second, so Senator Brockett, you have to
I
go.
have to go,
But-
but I had been thinking sort of along those lines, that if it's a drinking water source. Or that just the application in general should, in addition to what Michael read, should have. Like, the parking, and whether there's gonna be boats on the water, if little kids with a fishing rod on the side, that's one thing. Boats on the water is another, so it's and then notify the town so the town can give input. To whether the application is issued, but it's really all drinking water sources that are really iffy with gasoline and everything else on the boat, so that's all.
So you would remove the requirement that it's just for the
Yeah.
wholly surrounded
Yeah,
drinking water.
yeah, I'm thinking of drinking water sources.
Yeah.
Okay.
Yeah.
Okay.
Yeah, I mean, I sort of back to the thing I was saying before, like information and communication, we should start with that before saying, no, we're creating a whole other layer of approval, you know.
But how does that work on Champlain?
Yeah, that's the one that's weird, I don't know.
Or where there are multiple surface water sources. Multiple systems. I just think of it as what's the difference between 20 people fishing on a lake in the same day and 20 people trying for a fishing tournament? I mean, as long as the people that are involved in the fishing derby or the fishing tournament are following the rules of that lake or pond, like if it's not motorized, okay, then we're off in the shore. If it's, you know, I mean, you can only use this type of bait or you can only fish for, I mean, whatever. As long as that derby is following the rules of that lake or pond, then I don't see why the municipality would have the right to say, you can't have that fishing derby.
But
Is it an
they
expectation?
my understanding of this situation is that they did approve a fishing derby that violated the rules of the lake.
Okay,
That's
is they,
Department of Fish and Wildlife approved a fishing derby on Dick's Reservoir that allowed for ice fishing. And ice
Yeah.
fishing is not
It's not allowed.
allowed, that's
Okay.
my understanding, but I could be wrong.
So then a mistake was made. Then a mistake was made.
Yeah.
But I just don't understand why we would tell a fishing derby, as long as you're gonna comply, and it sounds like they did in this case, but as long as you're gonna comply with the rules of that lake, that the municipality would be able to say,
Yeah.
no.
I think we're agreed that
Yeah.
taking out the municipal approval is something that can come out of the bill.
Okay,
I think that's fair, and I think the question is, in its place, do we want, I guess I'm appreciating what Senator Hardy's saying about providing information.
Yeah.
And what would be the right information that would be useful in that decision, so notification to the municipality. See, just to be like, heads up, this is happening on your drinking water source, or.
Yeah, so I mean, I think what you're saying makes sense, but it sounds like what the information they're asking for. They don't have full information to determine if this fishing derby would be following the rules of the lake.
and
So that they need to ask for that information and make sure that the derby would be following the rules, and if it is, then it can be approved.
so
kind of thing.
we had this conversation the other day, I mean, what if on the application, you know, where they fill out everything, this is the date, time, place, these are the rules, the derby, you know, everything. If there was simply a box on that form, that application form, where the municipality had to say, we have reviewed this application and we understand what it's asking for. And then when it goes up to Fish and Wildlife's like, okay, I see that you have communicated everything about this derby to the municipality.
Oh, so you're saying that it's on the applicant to inform.
That's right, to check that box before they submit it to Fish and Wildlife.
So I have a copy of the application I got from the Vermont Federation of Sportsmen Clubs. And basically.
Is this
it says-
a state application
Yeah.
form?
Yeah,
Okay.
and it's actually a fishing derby that was approved in this area. Seminole here, but Chris Bradley spoke to the commissioner, this guy's name is Pinka. That approved actually has Bernard Pinka, authorizing agent, said that, you know, can you put a box on there that says, you know, municipality's been notified? And he said, yes, we can do that, because the application's online. So,
Well, I guess I think that's great that they can add that to but I also think that the department needs to verify it. Because what it seems like is the department can communicate with the city. And so.
So ice fishing is not under the use of waters that were prohibited on Dick's Reservoir. It was probably the public water system prohibited ice fishing on the water.
Oh,
And the department, following the Berlin Pond decision, said that they didn't have authority to prohibit fishing on that water because the General Assembly hadn't specified that it was not allowed on that water.
so,
And so that's, I think, the distinction to be made.
Okay, because what I heard from the city of Barry, or my understanding of what I heard anyway. Heard a lot about this, was that they said that there was no ice fishing, but maybe it was like the city regulations for the water source.
So the only restrictions for decks under the use of water tool shall not exceed 5 miles an hour. Personal watercraft is prohibited, aircraft is prohibited in May, November. Use of internal combustion motors is prohibited and wake sports are prohibited. It doesn't say anything about ice fishing.
There may be rules against that from the source protection plan.
But potentially, yes, that's actually a very good point. That's.
So that feels to me like a potential line of communication. Because the source protection plan would be with DEC.
Right.
And so, if there are rules for this, because it's a drinking water source that are in that source protection plan, that maybe Fish and Wildlife doesn't know about, like that feels like
yeah,
a conflict.
I mean, I think you can add a box to say the municipality has been notified. You could also add a box to say if the water is a drinking water source, the department shall determine whether or not the source protection criteria prevent its use for fishing.
That makes sense to me, and
I mean, I might go a little further than just having the applicant have to check the box.
Yeah, exactly, exactly.
Like I put like a signature line where somebody from the municipality says, I saw this application.
Yeah.
Just bang it up a little bit.
Agreed.
Applications are submitted under penalty of perjury if that
yeah,
makes any difference to you all.
yeah.
It should make a difference, yeah.
Indeed, yeah, go ahead.
yeah, it just seems to me, I mean, I understand Senator Williams especially in the winter. You don't want it to take so long that the ice melts, like if you wanna do ice fishing, there's like a small window. Most winters, seems like a pretty big window this winter, but yeah, but I also feel like I think having the communication and verification of all the relevant parties is helpful. And the information that's necessary, so. Does the application include whether you're gonna be using boats, and
Yes.
how many people and parking information?
Sure,
I can send you the application.
Yeah, that'd be great.
Yeah,
that's identify the name of the tournament, the sponsoring organization, contact information for the applicant, dates of the tournament, times of the tournament, location of the tournament, the town and county in which it's located in, the check-in location for the tournament, whether you're using the Fish and Wildlife access area. You have to describe any land-based activities beyond parking, launching. You have to the fish species saw, the number of anglers expected, the number of vehicles, boats expected. Tournament prizes. And then you have to affirm their penalty occurred.
Okay,
And key is somebody's, the responsible organizations on there too, so that's. If they go down there and find that somebody left a pile of garbage or
Yeah,
awful, then they know who to go to and get it cleaned up. So,
and do they have to have insurance? Is that one of the things that's required?
I don't think it's required, but I think it's probably advised.
yeah, because I mean, if somebody falls in there, ice fishing hole because they had too much to drink and drown, it's like, is there a liability for the town or the state, or is that on the Derby? Or is that, I mean, obviously, the individual, but you know what I mean, if something happens.
I have to confirm, but my intuition is don't. Insurance is not required, it's just advised because
Okay.
especially with all of the virtual tournaments these days that are multi-state, multi-region. Really?
You catch
Yeah,
virtual
you could be
fish.
participant in New Hampshire by, showing, a way station, check the weight of the fish and species.
Interstate fishing tournaments.
But that defeats the whole purpose, aren't you supposed to get the fish from the
Well,
place?
Same body of money.
So Senator Watson had me confirm all this, there's an app called Fish Donkey.
Fish donkey?
And the Fish Donkey is used to organize tournaments, and if the department learns that there's a Fish Donkey or other virtual tournament that you have to, or remote tournament, that you have to apply. You have to get a permit for that tournament.
Yeah, this. is
And
supposed to
then
be-
I bet you that it ties into the gambling app that
Maybe.
the state uses and people can wager on
FanDuel.
fish donkeys.
Fishing tournaments, it's not his thing, but all the other states are there.
Oh my goodness. Okay, so just to sum up.
I just said,
Okay.
We've gone down.
Yeah.
Fishing hole.
Sounds like we're taking up the municipal requirement for approval. We're gonna replace it with some kind of notification. And I was not hearing like total agreement about how that notification ought to look. Because either it's the applicant that is required to notify the municipality, or it's the state, or it's something like the municipality has to put a signature on the application, which.
I would say, how about a checkbox? That said, and the name of the person,
And notifying the municipality, it needs to be some like being clear that it's you can't just like call up any random person who answers the phone at the Berry Town Hall and be like, I've notified you. So some kind of official notification and that I mean, this is pains and perjury, but that the department verifies and also has to be. Yeah, I guess it's the select board or the city council or
Or their, list of things they do, they
yeah,
have to sign off on it.
Could I say the legislative body and this stuff?
yeah, that makes sense.
Sure.
But then. I just in the spirit of communication, like the Department of Fish and Wildlife should have to be able to be like, okay, hey, Barry, you're gonna have this tournament, we just want you, make sure you saw the
We will.
application and
they will.
so that,
So
yeah.
can we put that into, so in addition to asking Fish and Wildlife to notify the municipality?
So the applicant notifies the municipality, and then do you just give the commissioner authority to verify?
Sure, that
notification?
sounds great. That sounds great. I am interested in some kind of confirmation that the fishing tournament does not violate any source protection plan provisions.
yeah, I think that makes sense.
Yeah.
They. Department of Fish and Wildlife has to
Mhm.
check in with DEC to make sure.
Yeah.
Okay.
Okay.
What waters does this apply to?
That's a good one.
So it makes sense to me to, well, I'm gonna float this out there, just, that it feels like too much to try to include like Champlain, like,
Well, I mean, I think the way we're doing it now,
If we do it this way. It would just be a checkbox and people talking to each other.
But how many municipalities do you have to notify?
Oh,
That's beyond-
yeah,
that's true. If it's
so.
Lake Champlain, you have to notify all of them up and down the lake, is that?
So if we just call it, I'm just hearing
Inland.
Can you just identify yourself?
Oh, sorry, Jared Carpenter, Lake Champlain Committee. Rather than international interstate lakes, you could just say inland lakes, meaning they're surrounded by the state of Vermont. Now, you could still have some bigger bodies of water, but it wouldn't be Lake Champlain or Lake Petropac. Sorry.
If you do that, that should be in the place.
Okay,
That works for me.
so if we did an inland lake and it, you know, Lake Dunmore, which I know, because we keep talking about lakes I don't know. And it's the town of Salisbury and the town of Leicester or both.
In that case, you'd be notified both municipalities. The municipalities, which is, so the fishing tournament is located on the lake.
Are there fishing tournaments that might go into a lake from multiple access areas?
Yes.
Okay, so I was gonna say we could just do it for the municipality where the access area is, but if it's multiple.
Remember, you do participate in boats already in the water.
Right, and apparently if you're on an app in another state. Who knew?
Okay, do we have enough clarity on this?
I think I can bring you language, you might have to refine it, but
Okay, and again, from everything we just talked about, is this something that you all can live with?
It's a notification. It's
Yeah,
Yeah,
notification, not a approval.
exactly,
yes.
communication.
Communication, okay, you're okay with that?
Yeah, but we still need to do some work on the decon, so it's.
Okay.
Part.
So we got close,
Yeah.
we're not totally through
right,
this.
give 2 more pages.
Oh, gosh. And just to say it out loud, I would love to take a break at this point here as well, so,
Okay.
I think these pages though are about the fishing tournament.
They are, it's about, about your public access and the reimbursement of costs.
Oh, that one.
I feel like that might take a longer time than we have in this moment.
I'm just gonna put a break there then.
Okay, so we're very close.
Getting there.
Okay. And so
I don't even have to go to a fishing tournament now.
I know, now that we've talked about it.
The great bass fishing.
Yeah, let's
Probably
do it.
can't play, but
Okay.
you can bring fish caught in the lake.
So Mr. Grady, it is,
Sure.
as a question, is it reasonable to have you drafted this by tomorrow?
I can try,
Okay,
might not be edited by tomorrow, but
it's okay,
okay.
no worries, oh, and we're also looking for a new draft in 213 tomorrow as well.
Right, I think I just need one word.
Okay, okay, great, so. I think we're otherwise good, I'd like to take the 5-minute break.
Yeah,
Okay,
that's good.
and then we'll be back. Are you feeling ready?
And listen, do you want to talk to the side?
Go ahead. Sorry, say again? Oh, no, nice. Okay, this is Senate Natural Resources and Energy again, coming back from a break. And we are switching gears to talk about S325 updates to Act 181. And we're joined by Megan Sullivan from the Vermont Chamber of Commerce.
There you go. The presses.
My gosh, the universe provides. Amazing. Welcome.
Thank you. Megan Sullivan, Vice President of Government Affairs for the Vermont Chamber of Commerce. Looking at the Vermont Chamber and VNRC continuing to work collaboratively together. So appreciate you all continuing to hear from us on 325 as you work through the changes. Updates for Act 181. I think most of what I'm going to talk about are things that you've heard. There's, I think, one additional piece that was from the testimony, the joint hearing on opt-in, opt-out, we didn't have end of testifying, but you had great testimony from the other folks.
Right, yeah,
I'm happy to.
Right, we ran out of time
Ran out of
today
Yeah.
at our joint hearing, so.
So one piece from that, and then one other piece that's come up more recently, but otherwise, I think, generally things that you've heard, so. I will just jump in if that works.
325.
Okay.
Yeah.
320.
We're
I was trying to
0.2.
literally.
Who's here?
Who's here?
What are we talking?
What milk did this be? So I think. One of the first things, looking at the dates. What we would love to see is that 2030 date for the tier 1 exemptions.
And do you have a specific page that
That's in the draft 1.2. Okay. I think that starts on page 2. Line 11. Oh, that's priority housing projects. Well, let's talk priority housing projects. So, when we talk about priority housing projects, yes, I think, extending those to match with the dates of the extensions of tier 1 makes sense. The other piece on priority housing projects, that we see as really important is that those are available in mapped tier 1B areas for if the community doesn't opt in. So if an area gets mapped as tier 1B, but in the future land use maps by the RPCs, and the community says, we're not gonna opt in to tier 1B, the priority housing projects are still an option there, so that is the incentive of those housing projects not having to go through Act 50 or exempt from Act 50 in those areas. If you opt into tier 1B, that incentive goes away. If you don't opt into 1B, we would still like to see affordable housing as a incentivized option in those areas. And think it's important, hope that most communities are not choosing to not opt in because of not wanting to see affordable housing built, but I think it's important to say that this is a statewide priority. And so to say, in the areas that are mapped for tier 1B, if a community doesn't opt in, that priority housing projects can still be appropriate.
A couple of questions I'm seeing percolating. Okay, good.
I have written on my paper, and what is the definition of priority housing? Is there a definition somewhere? There is a definition. I don't have it memorized. Okay. Because Farrell might be able to. Okay, and also Alan, our drafting attorney, but that, I guess that would be my question is, you know, wanting to make sure that that was a reliable definition, so it wasn't just like. Yeah, and I think it's been, the priority housing project
program has been incredibly successful in helping get affordable housing, big A subsidized affordable housing projects started and moving in communities across the line because of the incentives that come along with that.
One thought, so just to, I'm trying to think about, how that might be drafted or framed. And what I am hearing is that there is no deadline on that, like, there's no extension on. There's not an extension with a deadline for that. What you're saying is that going on in perpetuity, if an area is mapped as tier 1B, that priority, like just going on into the future, priority housing projects should still be a program.
Yes,
it should still
reference
be
back to where they live in statute and say this program is eligible.
Even in those towns didn't opt into 1B.
Yes, specifically for towns that don't opt in.
Because if they do,
If they do that
Priority
incentive, it's already there
Right,
to not be, I think S102 may have an additional beyond that that was introduced last year. That would say in those 1B areas and maybe 1A as well, there is an additional incentive for priority housing projects so that incentive for affordable housing continues in those areas. As well as making them allowable in mapped areas that don't opt in.
The one hiccup that I could anticipate is if would a municipality, like, which is sweeter, I guess, is the question, like, is it would a municipality not opt into tier 1B so that they could keep the priority housing project? But I guess it wouldn't negate it wouldn't necessarily go away. The priority housing project program wouldn't go away for
And I think that's why the S102 had the additional incentive in those
places that opt in.
the places that opt in, so that our affordable housing community could still find an additional incentive for developers to create subsidized housing as well as market rate housing. So there is likely language. You might think about it, time to read that bill, but likely language within that bill that addresses both of those pieces.
Okay,
Look at.
super.
Okay, so that's page 2. And we have the extension for tier 1A, it starts on page 4, but I know the land use review board brought up changes on page 4 to the commercial conversion piece. We would agree with them on that. Where is this? Sorry. The line 6.
So like for commercial purpose.
So they had mentioned that there are some commercial properties that are predate Act 250, and so an amendment that would make it clear that whether it's a new construction or renovation.
I mean, this one is specific to converting commercial properties into housing. Are you asking for something broader than that, or?
No, it was just, they had mentioned specific wording for the construction improvements, that would leave out certain types of commercial buildings that predated Act 250.
I see.
I think Janet was gonna send language on that, just saying we would agree
Mm-hmm.
with that inclusion.
Okay.
Okay, then we get into the tier 1A, starting on line 10. Okay. And, there. What we had put forward was 2030 for those extensions. And. With the additional piece and also, appreciate what the land use review board said, that if a community. Opts in or applies for 1A or opts into 1B, that there will be a time period in which that. They're gonna be ramping up, and so having the extension go to 2030. For our housing targets, and then for those that opt in or have an approved tier 1A, that those go a year after that adoption. So you apply for 1A, you get approval for 1A, you got a lot to do to get up and running for 1A, and in the meantime, that starts the clock on saying, okay, 1 year from now, those interim extensions end. So we're on line 10, so the first date is 2028, we would like to see that pushed to 2030. Page 4.
Okay.
Yes, I think the LURP came in with. Suggested dates.
Yes, for that second piece.
Yeah.
Well,
And
1 year after.
Is yours the same as theirs or different?
I think the one, yeah, I know
I
this.
think the
I
chart,
think the 2030, I'm not sure they weighed in on how long the income exemptions should last for. I think there was some coalescing around 2030 by some of the advocacy groups.
okay,
But they had, dates there's dates for a lot of things.
Well, those are gonna be dates.
So
Years.
many dates.
Well, and what I'm also hearing is that. You're hoping for a year after.
For those that adopt, so this, the 2030 would be whether or not you
Oh, I see.
adopt, and I think as we see. Some of the other pieces of this needing to slow down and take time, especially around our communities, how quickly are those communities gonna be able to apply? For tier 1A, if they're getting their plans together, if they're making sure they check all the boxes, it might take them a few years to get that and not having those interim exemptions run out in the meantime. And same with that opting into 1B, we're hearing there's communities that are sort of waiting to see how it goes before they opt in, so keeping those interim exemptions available in the meantime with that end date of 2030 in place. But for those communities that are, raring to go and say, all right, we're gonna get our application in, we wanna do this. Having an overlap of interim exemptions and tier 1A or 1B. For 2 years might be too long, but that 1 year is, okay, you've got 1 year to get everything stood up, in the meantime, you've got the interim exemptions for the next 12 months.
Yeah, okay. Questions? I feel like I'm starting to want a new draft to just start to incorporate some of the suggestions that we've heard.
Yeah.
Keep it all straight. And I don't think I have received language yet from the ladies review board, but that would be.
I'm pretty sure they requested an extensions
Yeah.
of all of the interim exemptions until, but I can't remember which date it was.
Right, like I don't have. I have not internalized what those dates, but I'm also appreciating your suggestion about wanting a timeline.
Yeah, it would be super helpful.
It might be interesting to have like a timeline of this is the timeline of what it is in current law.
And they have that timeline of current law, so I'm sure this.
Right, and then the updated, like, this is what the new timeline would look like.
Well, like, this is what the LURP thinks.
Oh, yes, yes. Right, right, yeah. Or like, even if we started with someone's new timeline and then say, we agree with this part and that part, but not that, you know what I mean, just there's something to point at visually.
Yeah, so,
Yeah.
yeah, exactly, it doesn't have to be.
I mean, it makes sense. Thank you.
Okay. I think next, we're starting to talk about tier 3 rulemaking. And So this isn't,
And what meter are you on?
sorry, page 6,
Oh, okay.
line 12. So, one thing that I don't believe is addressed in this current draft is that piece that. Does every piece of criteria need to be reviewed if the trigger for a development is only. And I say road rail here because that's the shortest way to say construction of a road or driveway, or 2000. Does every criteria need to be reviewed? I think there were some during the period when Act 181 was first being drafted that thought that there was specific intent there that they didn't, but the land use board's legal team has said that that isn't there, so really specifically giving them the authority to, in rulemaking, determine which criteria would apply if the only trigger for an Act 250 working is the construction of a road or a restricted natural resource.
Yeah, I mean, I think the LURP was,
They were on
board with that, and I think it was a little bit even broader than just if the road rule triggered it, but also just, if there is a house in a tier 3 area that the owners want to subdivide and build a house for their kid or something like that, they would have a limited review as well.
Yes, yeah, I think you remember that, yeah.
Consistent with the purpose of tier 3.
Exactly.
That was the idea.
Yeah, so for both of those, the tier 3 rulemaking, and that's why we think tier 2 should also have rulemaking to do that. So in the tier 3 rulemaking, specify that they have that authority to contemplate a reduced review based on what the trigger is. Obviously, if it's a development that is, there are 4 different things that trigger Act 250, then you're gonna go through the whole review, but if it's just that one piece. Someone was talking to me about, well, there's the person who's been in the draft map and their son was planning to build a house. And if they built it through the driveway through a wetland, it would be shorter, but if they went around the wetland, it would trigger. It's like, well, so then in theory, they would send that to be reviewed and say, yes, the longer driveway is minimizing impact by avoiding the natural resource. Thank you, good to go. But that in theory is the ideal outcome. But not say, okay, well, now you should get a study on the impact of traffic and schools and communities and pay an engineer and a lawyer to tell you that there's something. No.
Right, but I think the point is that not just the road rule trigger.
Not just,
but just
for both, so it's
Yeah.
tier 2, it would be the road roll. For tier 3, it would be the natural resource.
Yeah. And then neither of those. They're not relevant to tier 1. The road rule is not right tier 1.
Well, that's an excellent question. I've got something to say about that. That was what I was gonna talk about in the opt-in, opt-out.
Okay.
And because I think that work is gonna take some serious consideration. I think that needs to reflect in the date that these both tier 2 and the road roll and tier 3 go into effect, because that's gonna need some stakeholder process and the rulemaking process, and to say on top of. You're already crammed deadline for tier 3, now you have this other piece of tier 3 you need to look at, that date should reflect that this is gonna take some additional time.
And are you agreeing with the land use review board's recommendation for the dates?
I'm not gonna lie, I struggled a little bit to understand what their date was. It was before construction season, but at 20, I mean, I think. 2028 or 2029, I wasn't sure where it landed, but in March timeframe.
I thought it was January because they were like,
Planning to do it now.
not during construction.
That was for the tier two,
Yeah.
road, for road rule.
Yeah,
And I don't recall what the tier three suggestion was, but you're agreeing that it needs to be extended.
it needs to be extended.
Yeah, the season is less important for tier three than it's.
Then for-
Yes, yes.
But
I
it,
think that's one of them.
yeah, I think this should probably move out in here to
Mhm.
that work and you know, and. I think rulemaking is the right way to do that, though, if you. Make sure to have folks back in and see how it's going, that would be, you know, I think that oversight authority of on this committee is important. So. I don't know if that gets us to the road rule yet. But this isn't in here, so. Something new and fun. The road rule applies to tier two, and tier two is everywhere that tier one and tier three are not. If you are a mapped growth area and you do not opt in to 1B, the road rule now applies where your growth area is, and I'm not sure that was the intent.
Can you say, can you say it again? Yeah.
So. Tier two is everywhere tier one and tier three is not. Tier one is either an opt-in or an application. 1A, you're applying for tier 1A status. Tier 1B, you're opting in. If you do not opt in. Now that area that's been mapped as a growth area for you would be under tier two. So what's mapped as tier one, you didn't opt in, now it's tier two. And you have the road rule applying.
So this to me is getting at the distinction between the land use review board's maps to say, here's where it's tier one eligible versus this is a tier 1B area.
Right.
Is that, it's like we use a
Yeah.
different word to distinguish like the eligible.
Right, eligible versus opted in.
And can there be a growth area and then opted in?
Yeah, so we heard examples of Colchester and Essex are not opting in, but they have growth areas. Because I don't, you'd have to have those communities in to ask them why, but in theory, let's say their community says, you know what, we want the work to do, they're have to do your review here. So we're not gonna opt in.
I wonder though, I mean, what we've been hearing is that the reason that places are not opting in is because they don't want to take care of all of the previous Act 250 permits. And
That's one of the reasons,
Oh,
I
that's
don't think
one.
that's all of the reasons.
okay,
Yeah,
but so they don't want to do 1B?
some are not opting into 1B, and so that's where we're sort of pushing and like, well, if it's because we don't want affordable housing, we're going to nip that, but.
Yeah,
But some are also saying like, you know what, we don't wanna we want the land use review board to do these reviews, so we're not gonna opt in because we still want them to do that review.
I see.
But they don't necessarily want the road rule to trigger in their growth area, a review of every development. So if the road rule was the only thing that triggered in a growth area, should they go through the
I need
process?
more information about what a growth area is.
Sure, maybe that's something we can ask Commissioner Farrell,
Okay.
because he's next.
Okay, so.
Yeah. Yeah.
And the VLCT always is good, but they always have maps, so they might have maps today. Of course we do. Yeah, there it is. I'm West, not Oregon.
Just about the words.
Okay. So that was. The piece that I was gonna drop the other day, but I think it should be at least considered, do we want? The role in those. Match growth areas if someone doesn't opt in. Agreed.
Growth areas, you actually mean 9B.
I mean, the 1B, the areas that are mapped for 1B, yes, yeah.
As opposed to the technical
The
term.
future land use mapped
Mm,
growth
I see,
area,
right.
which will have the map 1B areas.
Okay,
If they do opt in, the road rule doesn't
Doesn't
apply,
apply.
it's just about the opt.
It's just the people, right, who don't opt in. I mean, was the consideration that would, if they don't opt in, I'm not sure it was ever considered. Do we want the road rule applying there?
well, and just to. Conversely, is that a reason to opt in? Right,
There's
like,
so many good reasons. to opt in.
that's the benefit maybe that you
Yeah,
get to enjoy.
There, like, that's one of the incentives for opt-in,
Yeah.
and if we take away that incentive, will actually fewer towns opt-in. You know, sometimes it's a unintended consequence situation.
Just thinking of.
yeah, well, and I think sometimes, if towns aren't opting in. Because they don't want development, they don't want the help, say, meet a housing goals, sometimes we have to. Push them along with that, so maybe it's like a nudge. Yeah, say, yeah. If this is about stopping development in growth areas, as we're trying to say, we need more housing.
Why would they say it's a growth area if they don't want to go over there? That's what I'm pursuing.
I think it's the land use review board, no, I guess it'd be in the municipal map,
PCs, right?
yeah. Yeah, it's curious.
There's 250,000, I want to assign
Worth
feelings to all of them,
I
but
think it's
I
200.
think it's 252.
Yeah, Essex.
Yeah, well.
Anyway,
Municipal study. Oh, the land use review board, what they had about, what they were talking about in terms of. Keeping the permits with the land use review board. For those tier 1A areas and then them sort of slowly moving over. On board with that, as well as if someone dissolves their 1A, that those would obviously fully return to the land use review board. I think there were some language on that, so, but we would agree with that. The guidelines on page 9. Think that's important, I'm glad it's in here. That, as those. Well, I think. Just ensuring that we have consistent guidance being given to folks is really important. I know there's a lot moving and everything, land use reviewers being asked to do a lot, and so as. They learn more and engage more, things might change, but I think consistency is really key in creating trust in this process.
sorry, you're talking about section 6?
Sections.
Yes, oh, the,
Yeah, I might have a note that the LURB doesn't think this section is necessary.
I respectfully disagree.
Okay. I've noted that.
okay, thank you.
And then the appeals report, I know it says tier 1B appeals report, but. Maybe it's okay just to say municipal appeals report, I think that's the focus of this is the municipal appeals. And. Would recommend that living with PHCD. Well. And then again, I think we're looking at some different proposals that groups have come up with, both the PHCD, 82 homes, as well as Let's Build Homes with the root zone. So I think having Let's Build Homes as a part of that group makes sense since they're doing this work as well. Section 8.
Yes. Cause it's in consultation with a whole bunch of groups, you're suggesting that we add.
There's 2 homes,
Was that?
adding there 2.
And well, DHCD has 802 homes.
Wait,
so
so are you suggesting they take the lead on it?
I'm suggesting they take the lead
Yeah,
on it,
it's the
taking the LURB out of it.
LURB does not want to take the lead on it.
Yeah. So
According to my
You're excellent. That's all we've got sometimes.
I think since DHCD is already doing some of this, that this makes sense for them to take the lead on it.
Okay.
And doing the state agency needs that it's administered by the state.
Yes.
So,
Board would still participate.
sure, I mean, you can add them as a participant.
Makes sense.
Yeah.
I mean, I suppose we could also ask them to they participate, but.
I think they would be okay with that. It's just, yeah,
They just don't want to take the lead, because they were like, this is municipal zoning for us,
Right.
that's not,
That's what we do.
yeah.
Yeah. Okay.
and then the last piece that is not included in this draft, that you may not have heard much about yet, that I just talked to A&R recently. Is in the list of, criteria to have 1A status. There's, I think, 11 different things that a community needs to have in place, and one of them is about natural resource planning. And the word rare is included in the rare, threatened, and endangered species. But in Act 250, including the new 8C, the only review is around threatened and endangered. So the inclusion of rare species goes beyond what Act 250 reviews, so we're asking towns in 1A to actually go further than Act 250. And apparently has been a bit of a challenge to try and figure that rare. No problem with threatened or endangered, just the rare piece. And if you ask me any questions about that, I will defer to, something about threatened and endangered species.
It's the first, so
Yeah,
it's a new issue.
You're welcome.
Yeah. And so really, what I'm hearing that you're suggesting that we strike the word rare from T.
Rare from the tier 1A, meaning threatened and endangered. Because that will then match what we're asking tier 1A to do with what Act 250 does. If that's the idea, right, it's a designation.
Right. You're not suggesting that we add the word rare.
No.
Criteria 8.
Yeah, 100% that.
Okay. Just thought to clarify.
Just keep
Well, should consider them just the burden if not doubt. In foundation.
Well, I wanna just hear from A&R, because it could be a term of art, and I'm wondering if we make changes to either one, if it's messing with some federal requirement or something like that, so I just want to hear from them about that. I mean, I hear you.
Yeah.
Noted.
That's
Yeah.
just.
And they had flagged for me that this has been a challenge for one of the communities that's trying to get 1A status of figuring out how, like. Rare is
Right, how do
a whole different ballpark.
Yeah.
That I don't. know
you?
that, but so it's been a challenge. Makes sense. But
Okay.
not keeping those threatened and endangered.
Yes.
We're all there.
I think
Doesn't rare imply? That's why I'm wondering.
I think it may be a,
Yeah.
right, S1 versus S2.
There's
There's tiers.
There's tiers.
There's tiers. Levels of endangerment. Yeah.
Okay, I think those are all of my notes. I will email them to you.
Great.
But thank you for doing this, I think it's important.
Yeah,
Appreciate it.
thank you.
Exactly on time.
Amazing. So good.
Those good branding points, right?
Okay, so we're gonna move to Commissioner Carroll.
Job.
Welcome.
Thank you. Thanks, Madam Chair. Nice to see everybody.
Same.
Okay, for the record, Alex Farrell, Commissioner, Department of Housing and Community Development. I'll start by saying I think Billy Costa would be really good to hear from on that rare issue. Because like Megan, I'd just be trying, I think.
Who's Millie Foster?
We've also.
Agency of Natural Resources.
Oh, okay.
All right, so I've got a very brief slide deck. So my goal today, I know there's a specific question around the study, would we be okay leaving? Megan volunteered me to do it, so what can I say? No,
You have to.
my goal is also to just give full transparency upfront as to what the administration wants in these realms, so that there's no surprises as the session goes on. And this is largely already laid out in really two bills that fortunately are right here on the wall in this committee. Both administration housing bills that were introduced by your very own Senator Beck. So I'm gonna start with my last slide here. Which is just to say, S-267 is the administration's bill, which touches on a lot of these. Is it okay? Good. Which touches on a lot of these same issues, and so a good way to find out where the administration is on all of these would be really where we stand at S-267. I'm gonna walk through that at a very high level in a moment here, but the language is already there. I know sometimes that makes things easier if we can just look at language rather than have me describe it from the chair. The point of this slide though is also to say S-267, which was this year's administration housing bill, builds upon S-102, which is last year's administration housing bill. So some of the nuanced stuff, including some things Megan was talking about, are in S-102 and not in S-267, not because they're no longer priorities, but because they're already in a bill that's here. I'm gonna jump to this issue right here, which Megan flagged, and the chamber and the administration independently arrived at a very similar solution here on priority housing projects. So I'm thinking of my partners at VHCV and the nonprofits with this. We performed a study jointly with VHCV and VHFA last year, actually rather before last session. That study asked us to determine what's the future of priority housing projects when there are new exemptions that are brought for market rate. How can we make sure priority housing projects stay relevant? So in S-102, what we proposed was a version of what Megan already outlined here, where if you're in, and I'll just say that the future land use areas that are tier 1B eligible would be downtown center, village center, village areas, and village area and planned growth area. Those are the two neighborhoods. So if you think centers and neighborhoods, those are the future land use areas. So downtown center, village area, planned growth area. Those are the future land use areas that would be eligible for tier 1A and 1B. You could have those areas mapped without opting in. So to 1B. So those are the areas that I'm talking about. So if you're tier 1B eligible and you opt out, like what the chamber just laid out, PHPs up to 50 units would still be the regulatory incentive. In tier 1B areas where folks do opt in, I propose pairing with that a 50% bonus if you build a priority housing project rather than just a full market rate project. So you get a 75 unit cap if you do a PHP. So for VHCD and the nonprofits, this would give them more regulatory certainty that there's a relevance in the marketplace for them. I won't try to testify for Gus, Seelig, or Polly. I'll let them speak to whether or not that would be useful themselves.
Can I just stop you for a second?
Oh.
Your slides, these are different slides in letter, right? Did you update them?
Late last night, early this morning,
I haven't loaded up this latest one. That's okay, I'll just look up on the screen.
Oh.
I'm just like, wait, what, they're different.
other slides would be more consistent.
Okay.
Oh, and then just a flag in our policy bills where there are appropriations, things like that. They're really, you can ignore them. What's in the budget is what matters. Ignore those are placeholders. All right, let's Tarantino and go back here. So comparing draft 1.2 of S-325 to S-267, I'm gonna flag one error that I made in your bill. But I just wanted to give sort of a side by side where things line up. So I'll start with extending the interim exemptions. In 1.2 of 325, there's extensions. Looks like there's an effort to line some of them up. So some are 1-year extensions, some are 6-month extensions. I think trying to get some of them on similar dates, similar sunsets. We did something similar in trying to align them in S-267, but like some of the advocates, we moved all the dates to July 1, 2030. So that language is in S-267, but again, moving those dates out to 2030 for the interim exceptions. There is also a change in ours to remove the exemption only qualifies for parcels under 10 acres. In S267, we propose to remove that constraint. We've seen a couple projects where the parcel is over 10 acres. The project, the impacted area would be less, but just across the board, this is not unique to the area of exemptions. The way Act 250 will look at a project is tracts and lands, so it's gonna be the parcel or adjacent parcels, and so we moved to strike that from the interim exemptions. Now I have it here that S325 has a road rule implementation extension. I think I'm misspeaking. I don't see, as I look at 325, a road rule.
It should be there.
Okay,
It's not, you're not finding it, it should be.
then I saw it and I'm, okay, so I was ignoring that, I was right. And a tier 3 implementation extension. S267 proposes repealing the road rule. Pretty divergent approaches there, recognizing that, but I don't want anyone to be surprised as to what's being proposed by the administration. Tier 1A, so some overlap with what you heard from the chamber and what you heard from BAPTA late last week as well. Removing the sort of requirement for municipalities to assume 1A municipalities to assume jurisdiction of permits in those areas. S267, the language largely matches what's in draft 1.2 of S325. However, oh, yes.
Oh, maybe you're about to say this also. I was just curious, the first bullet point under tier 1A, allow municipalities to contract, what does that mean?
Yeah, sure. So in tier 1B, there's an additional provision that says capacity needed to update bylaws to do the things to achieve tier 1B. Municipality can contract for capacity with regional planning commission or another. We carry that up into tier 1A as well, so that a community could seek tier 1A status without currently the requirement is that you have staffing capacity, permanent staffing capacity.
For 1A.
For 1A, that's right.
Okay.
So the proposal in S267 is to allow that capacity, not necessarily requiring it to be permanent staffing at the municipality, but allow them to contract, but that's still.
Yeah, I mean, if we had like real regional government, that'd be helpful.
I don't have to weigh in on that. Another thing that you've taken a lot of testimony on is tier 1B. S267, as with S102, proposes to change opt-in to opt-out. So the final piece in S325 that I believe you all were interested in, our opinion, is would DHCD lead the study? I'll give a caveat to a yes. If the study remains in here, if someone's going to lead it, we'd like it to be us. I agree with the chamber that I think it makes sense to broaden that to municipal appeals rather than simply tier 1B. It could be noted that that should be incorporated, but I think broader study makes sense. What I'll offer is the administration position is we don't necessarily need to study this issue anymore. In S102, we would point to some of our appeals proposals there as possible solutions. But I think more relevant to what we're proposing this year is in S267, there are 3 sections which have to do with these pre-approved designs, which is a step in the direction of alleviating some elements of this appeals problem. You've probably heard other groups talk about by right housing and doing more in the plan to alleviate some of the appeals challenge because things would be pre-approved. So I'm going to dive into that a little bit more. Those are the 2 sort of non-Act 250 sections in S267 that I think would make sense in S325. So I'll start with, you've already heard a bit about this. I think Deputy Commissioner Formulari was in here and gave a passing glance at this. Jake Hemrick from our team talked a bit about this. But sections 8, 9, and 10 in S267 take the concept that's already being implemented right now with 802 homes, with pilot communities where essentially communities will have the option. Any community could take the designs that will be published later this year and choose to adopt those pre-approved what sections 8, 9, and 10 of S267 do is establish that DHCD has the authority to designate designs as pre-approved, sets out a process by which DHCD would have to undertake public input, have a public hearing, or adding any designs. And then adds to, there's a list in Title 24, there's a list of restrictions which municipalities cannot zone, and this would just be adding these designs to that list. So it would establish these as pre-approved statewide within residential districts respective to whatever the residential zoning district is. So the 4-unit wouldn't be pre-approved in a duplex and single family home district. It would only be 1 and 2 unit homes there, if that makes sense. Just to state, and I believe Jake got into this a bit, but even in this case, the units would still have to comply with other regulatory municipal regulations like setbacks and other things, but the design would no longer be discretionary.
Can I just jump in here? Maybe you have more to say about this specifically, and then if you have more to say about this, I'm happy to hold my question.
No, please go ahead.
Okay, so something that there's 2 things really. So when you talk about I'm appreciating the pre-approved, or I guess another phrase might be like pre-permitted designs. I think that's a better phrase than by right, so to speak. I think it's more actually just descriptive.
Yeah.
One question I would have about that is pre-permitted for what? Like which pieces are you anticipating? Which specifically, which permits would you anticipate bypassing? I feel like that has only just had a light reference, as we've talked about this so far. So that feels a little unclear to me, not that, because it.
Sure.
And I'm sure there's more clarity that could be, that's there, you know, that's, that I just don't know. But, so that's one question. And then the other question that I have is, because right now you all are, this is being piloted in 3 municipalities across the state. Awesome. Love that is happening. Is it accurate to say that there's not right now in the works a report back on how it has gone for those 3 communities?
That's correct. The pilot is just launching and the designs aren't published, and so this is drafted to take effect July 1, 2027.
Okay, this, for what it's worth, like this is an aspect that I am interested in, which is, you know, one of the reasons why I feel like a study or something makes sense. But I would love to learn from the experiences of those municipalities before we just plow forward with implement.
I will also say that I think what we have now is a bottom-up process that seems to be gaining traction. And I think if we try to impose it, the opposite will end up with less. And we're running more.
I'll offer that this is admittedly actually very incremental. This would only be 10 designs. It's really only development review that would be pre-approved. So other regulations would still apply, state permits would still apply. So we're not bypassing all regulation here. So this is actually a very incremental approach to this. And putting in statute now gives us the ability to build upon it down the road.
Thank you. So I think we got testimony on this before from somebody in your shop, and it is quite interesting. And the 3 communities, it's what, Manchester is one of them, and Hartford and Willis, Essex Junction.
Yeah.
I mean, I think I agree with the chair that we have a tendency in this building to create pilots and then put them into law before we have found out how the pilots work. Or to, you know, create pilots before we actually do a study about whether or not a pilot is a good thing. I'm not referring to anything in particular, but so I guess I would just say that I would like to hear, I think this is a really intriguing idea, and but I would like to hear how it works first. And so like pre statifying it seems, yeah, too soon.
I'll offer, I'd say the administration position on the whole is that there is urgency and urgency. So these solutions,
For sure.
we aren't eager to study things. Because not that we don't want to study things, we want to study based on evidence we have. We've looked at South Bend, we've looked at Kalamazoo, we've seen how this has been successful in those
Yeah.
communities, so we're modeling that. And we're being thoughtful in our implementation, and so holding back from a more broad implementation. When we do have a path in a housing crisis, we feel is not meeting the moment.
So that's fair, but when is the report due? Like what's the timeline on the pilot?
So there's no report due. This is something we've undertaken on our own. The pilot is underway now. The designs have been shared with those 3 communities and public engagement over the last couple of weeks. The final designs will be published in the fall, and we will also over the summer be working with likely a developer in Manchester on a demonstration project utilizing the designs.
Okay. And this is just something, I'm sorry, this is just something that you guys are doing on your own. It wasn't a legislative, it's not in statute anywhere.
That's right.
Oh, interesting. Okay. I'll ponder.
I think it's got huge potential. And but I'm lucky to have it not be bottom up and buy it with it's been built, with been moving. And so I'm very skeptical of this idea.
And you're.
So I love the program. It's brilliant.
And if I'm not mistaken, so the proposal that the administration has would be that it would take effect that this would be statewide by July of 2027.
That's right.
Yeah. Okay.
That's soon,
That is
that's next
soon.
year.
Yeah. Yeah, so again, public input would continue on the 10 designs that are being developed throughout this entire calendar year. And then there'd be, a 6-month sort of final public input process where we can engage with the league, we can engage with municipalities after they've seen the final designs. And during that 6-month period, adjustments could be made if there's.
I will say, I just connected a constituent of mine who heard about this,
Great.
who's disabled. And wanted to make sure that the designs are good for people with disabilities, and he's not a senior citizen, he's, in his 30s or 40s and wants to have a house design that could, accommodate him. So I do think also in your outreach, you need to be talking to, maybe you already are, but community, Vermonters with disabilities and other issues to make sure your designs accommodate everyone.
Absolutely, a requirement in our contract is that accessible designs be included. We're also working with AARP right now to potentially add additional designs that they could choose to fund. So it's very much top of mind.
Okay, he had some really specific, really good suggestions.
Okay, that's great, thank you.
So your shop is considering adding more types of designs.
If we did, we would have to go, according to this language, if it were mandated statewide, we would have to go through a public engagement process and have a public hearing in order to add any designs. Now, we could go ahead and add designs on our own, right? But without this language, it couldn't be, a new design couldn't be mandated without us going through that public engagement process. That makes sense. So you can add a design, make it open source for any builder to use. And optional, but it wouldn't necessarily be by pre.
What about, sorry, I'm just still thinking about it's our middle ground.
I am wondering about, so effectively what the pre-approval would be like a development review board's approval.
That's right, or historic review.
Both. Okay, and so it would not include things like a fire permit.
That's right.
Okay.
That's right.
Okay.
It's just discretionary.
Mhm.
So the municipal zoning administrator would still have to sign.
Okay.
And all the code
Okay.
compliance too.
Code compliance as well, and code compliance would be incorporated in the design, so we engage in fire safety to ensure
I
that.
mean, it should be seamless, but
How did you pick the 3 communities? Did they raise their hand or did you go out and recruit them?
It was such a good story, we put out an opportunity for what we call development ready communities to participate in this pilot. And we weren't sure what the response was gonna be, we got an overwhelming response. We only had the resources to choose 3 communities. But I wanna say 26 or 27 communities applied. And so we set some criteria based on, we wanted geographic diversity, we wanted a mix of towns, in terms of size. And then we also wanted to ensure that we did have communities in this the pilot phase that had municipal staff that we could administer.
Yeah.
So we were a little bit constrained in terms of we couldn't go too small of a town, but we got a good geographic mix.
So, sorry, unless you.
No, I'm still mulling here.
So. These are towns that you are supporting in this process. Is there anything prohibiting municipality from adopting this on their own, moving on to the future?
That's right, without any statute and status quo is and will be, these are open source. Any municipality can choose to do with these what they will, any builder could use these and save 10% of their building costs by not having a great sign, so. That you're absolutely right, there's nothing preventing municipalities, I think to Senator Baumgart's point, from use the term opting into these assets.
Right, so the proposal, I'm now starting to frame this as like, oh, this is an opt-in versus an opt-out. And where a lot of municipalities may not even know that this is an option. And not know how it has worked. Another thing that this raises for me, but because I don't know if there's overwhelming support, or there was a response, that there was interest in this, that maybe municipalities know more than I am, suggesting at this moment. But I guess I'm also wondering about, based on the experience of those 3 communities, is there a plan for outreach to advertise, how it has gone?
Yeah, that really, I mean, part of the logic behind choosing July of 2027 was that even after the pilot concludes, we then have months, 6 to 8 months to do public outreach, pull more public engagement. Maybe I'll fill in some of the gray area here with what we're thinking down the road. The reason we're interested in a statewide implementation across the board is part of this is we're requiring that these designs be both traditional on-site construction and the vendor is also developing them as off-site construction, so modular and panelized. The reason we want to do that and the reason we want as much sort of bulk certainty right off the bat as possible is that's our greatest chance at getting engagement from modular manufacturers either in Vermont or that are outside of Vermont, because they know they have predictability. So if they can be sure that municipalities across Vermont will accept these designs based on design review, that's a little bit more certainty that in a factory, they can churn up 50 of these units because they didn't go to Vermont. Right now, they don't have that certainty because theoretically, you have 252 different thoughts on what the design will be.
I'm wondering about, and I have not fully baked this, so I'm gonna just say it. But since this is a pilot that you developed on your own, which, you obviously you're welcome to do that, and it's great that you did. You don't need us to ask you for sure for things like this, but I'm wondering if we put in criteria about the pilot and its success and its outcomes, that would trigger more of an expansion if you met those parameters or criteria. And maybe it wouldn't be a full statewide expansion yet, you'd have to come back and talk to whoever's in these chairs again, but it could be somewhat of an expansion. I don't know, just sort of like a phase in, so it's not a automatic expansion or a statewide thing automatically, but there's some kind of middle ground. That's what I'm trying to figure out.
No, that makes sense, I understand. I'd be I'd be happy to engage to see what that could look like. I'm sure for all of us, hard to say without seeing a specific.
Yeah, cause I mean, if this is, I also not sure the timeline for the pilot, I don't know exactly what your goal was for the pilot, was it just to get the houses designed and get 3 towns who are interested in that, or were there further goals? And so sort of fleshing out what the pilot actually means,
Sure.
and then before it could move on to the next phase with more
Sure.
incentives.
And I'd be happy to talk more about that to help flesh this out. A good portion of us wanting to do a pilot rather than just create designs. We wanted the municipalities to help us. And tell us what they would want to see, and that's why we chose 3 different municipalities with some slightly different looks in their difference. But that's just one of the outcomes.
Yeah.
As well as we'd like to see at least one demonstration project.
Yeah, I mean, I'm interested in the municipality experience, the developer experience, the the community experience with all of them.
The homeowner.
The homeowner, yes, yeah.
Are they nice to live in?
Yeah, yes.
Sure.
Yeah.
No. Is anything to add? Some?
No, I don't want to beat the sports, but I just think that getting municipal body will make it work much better, because this is, talk about administrative purposes, if it's imposed, we're gonna have municipal resistance as opposed to buy-in. And I think we'll get more housing built. This will probably be more successful if we let it be bottom up and not make it top down. That's the way.
I'll offer that. Senator, that's fair. I mean, I think during the Home Act discussions, we heard a lot of that same challenge, right? We're struggling with how much are we comfortable mandating from the state level, because we're recognizing we're in a crisis. And so there's some discomfort in this building, always is, in creating a mandate that pushes municipalities. I'll offer that I think we struck a good balance in this. I'll also offer though that we wouldn't propose this in a vacuum. This, along with some of the other statewide permitting proposals, is really, we're trying to give the municipality something while also asking something of them and builders. This isn't just asking something of municipalities, it's asking something of builders to fit into a box.
I also want to make sure that we get to your next slide.
I think you can get buy-in.
Okay.
I think that's dollars will want this. I think you get buy-in.
Yeah, I think so too.
Yeah. I can be quick on this slide because I think this may generally fall in Senate ED's jurisdiction, but I wanted to cover it here so you know. Another element of this bill, section 11 of 267, which may be a good fit in this bill as well, is incorporating the municipal housing targets into the municipal plan. And this is a pretty relaxed approach to this. It's not mandating that zoning be updated to incorporate to enable the targets. It's not mandating that municipalities do this right now. Upon update, they would analyze and the housing targets demonstrate that they can accommodate those, or, and what we see is actually the more important piece of this provision is, or if they have constraints, can't meet the housing targets that the RPCs have set for them, they should catalog what those constraints are, whether it's regulatory, infrastructure, which I suspect water and wastewater is going to be top of the list for most municipalities, or some other constraint. So that's this seems to accomplish.
Okay.
That's actually our jurisdiction, that's the planning.
Yeah.
Oh, great.
Planning.
Look at that. Thank you, Madam
You're
Chair.
right.
Thank you.
Okay, thank you very much. And so glad you all are working on this 802 homestead. It's very cool.
I'm actually.
Yes, you are. Welcome.
Thank you.
Diving a little deeper into 325. I mean, we've heard you already on this, but love to hear some.
Yes. Well, first of all, as others have said, thank you for having this bill, bringing this bill forward, and thank you for inviting the LCT and the other testimonies today to discuss it. This is vitally important to municipalities across the state, in particular. Small low capacity rural communities. Quick overview, I actually wasn't. Let me say first, Madam Chair, I have pictures of maps, more just to like be interesting and exciting, not to discuss. But time permitting, I could pull up the FLU. I have an FLU testimony on this question of like, what is a mapped growth area as opposed to a 1B growth area? So time permitting, I'm happy to discuss that, so future land use area. So anyway, so I'm gonna go through the bill with comments on a number of the sections. I'm gonna hop around a little bit, but so I kind of went by jurisdiction rather than by section. This is how I understand the new proposed timeline in your bill, S 325. And so I thought I would stop here, pause here, so we could see these, because I'm gonna suggest changes.
Right.
So you discuss extending the PHP exemption to 27, the other Act 250 exemptions to 28. Tier 3 rulemaking February of next year, with jurisdiction applying in Tier 3 on parcels in Tier 3 in July of next year, same with the road rule jurisdiction, and then the new Tier 1A guidance soon this fall. So our first recommendation, this, I hesitate to say anything is the most important. I think this might be the most important request that we're making, which is to require that the final Tier 3 rule, we're on our third draft. But to require that the final Tier 3 rule be reported to the legislature no later than November 15th. And one important reason is that this allows legislative intervention if necessary. So for example, the current draft rule in the types of development that are exempted, utilities are not exempted. So this committee or the House Environment Committee, House Energy Committee may determine that that's not appropriate, that you don't want duplicative state permitting processes for telecommunications or energy utilities. If that's in the final rule, we feel you should have an opportunity to add a legislative guideline if that is important, well in advance of the jurisdiction taking effect in Tier 3 areas. So that's the most important reason. We have our own sort of local reasons, which are that an earlier rule will allow some of the municipalities and RPCs still in their regional planning for the Tier 1 FLUs to see the draft. If it comes out in February, that opportunity is kind of out the door for anyone. If we could really roll back the clock and go back in time, wouldn't it have been nice to just see Tier 3 first, but. And then, basically, if you could pick the worst month of the year to issue something vitally important for municipal officials to read, it would be the month of February. As you know, Madam Chair, as a former elected municipal official, there's zero capacity at the town level right now. So the fall and before the legislative session, before the municipal budgeting season and municipal elections kick off, would be, we think, the best time to review the final. Second recommendation, so the LRC has said that they plan to issue road rule guidance. Putting aside concerns about the Tier 3 rule and like specific concerns about habitat connectors or exempted development, non-exempted development, sort of putting aside that category of concern, I think the most frequent concern we hear specifically from zoning administrators is where is the road rule guidance? We need the road rule guidance. Because the municipal planning processes and communications and public engagement processes are long and require a lot of work, mostly volunteer capacity. And they are sort of desperate to understand what the road rule is, how it will work, how it should be applied. And they want to see that guidance in time before the jurisdictional change so that they could adapt and evolve in appropriate ways their own local code so that it's working together with the road rule and not in conflict that creates jurisdictional gaps or duplicative jurisdiction, if that can be avoided. So we actually suggest that S 325 add a requirement that the LRB issue the road rule guideline that doesn't currently exist in the law. And that be on the same timeline as our suggested date for the tier 3 rule, which is November 15th of this year. And in both cases, we support the jurisdictional extension going out to the summer of 2027. I don't know if anyone has discussed this yet today. If you'll remember BNRC touched on this at, I think, the first joint hearing, maybe you'll remember, if not, I'll remind you. And I'll add that today, Brooke Fingeldine from the LRB, a member of the LRB, met with the Rural Caucus and she also discussed this. So basically, so VLCT has had a number of meetings with LRB members about a number of components of Act 181, including some months ago, many months ago, we specifically asked, why does a tier 3 development need a full Act 250 review?
Can I ask before we move on to this? The LRB suggested the road rule going into effect in the winter. Are you suggesting it going into effect in the summer? Are you July? Because you were saying July, because they were concerned that that's in the middle of construction season and that might. Because so they were suggesting moving it to, I had written down 12/1/27. But I don't know, maybe it was 1/1/28, I don't know, but yeah, so.
That's a great, I'm glad you fleshed out that specific concern, because whenever the road rule takes effect, it is the largest jurisdictional trigger in Act 181. It will cover the most area. Whenever it takes effect, it will change someone's development plan and development timeline. But probably many people's development plan and development timeline.
Right, so they were thinking summer is when people might be building something, so do it in the winter when people.
Right, but the permitting would happen before the planned construction. So the jurisdictional trigger will shape the permitting navigation as much or more than the construction, the beginning of construction, because that project will be permitted or not permitted by the time they break ground, right? Well, it will be permitted by the time they break ground. And that's why we think this 7 months is so important. So have the rule for tier 3 and the guideline for the road rule come out in the fall. And then have the 7 months and then have the jurisdiction apply in the summer. Post session and sort of along the normal timeline of effective dates of changes in state laws and municipal preemptions. July 1 is a date maybe we don't all love, but we all know. And
Right.
you know, that like, so that's our thinking, is that distance between when the rule is issued and the jurisdiction applies is critical.
Okay, and that's a good distinction between construction and permit process, but I just was noting what they suggested, and that was their logic, was it's in the middle of construction season, but you're right that it would have to have a permit beforehand, so.
It might
Oh,
be an
and
important
maybe it's
thing to
the
hear.
extension, actually, that's what I'm thinking, they suggested extending it until the implementation, because.
It's set to take effect this July, if S 325 didn't pass, the road rule would take effect July 1, 2026.
Right, so it's basically just another summer of being able to.
Okay, so back to this provision. So basically, so many months ago, we went to the LRB and we said, why does a development, especially a development like a sugar shack or a gardening shed or ADU, why does that need a full Act 250 permit review in tier 3? And our discussions with the LRB at the time were like, well, we can't make that decision. We don't have discretion. The law says it's in or it's out of tier 3 and it gets a full Act 250 review or not. since then, they have discussed and indicated that they would be favorable to this change where it could be considered that full activity review is not required. I think there are other parties who feel they have this discretion now. I mean, that was my reading of it 6-9 months ago. Frankly, in any event, it's not their reading of it, it's not what their general counsel is advising the LURB to do. And so this language is in H 730, the Rural Caucus Bill. And I think there's common agreement and support for this change in language and would really like to see it brought into your Senate bill. So this, yeah,
Sorry, to say that, a question on this language, because it says if a criterion under Timmy say is not recommended for review under tier 3, it should be defined in the rule. Okay, so it's defining, just so I can understand what that is suggesting, it's saying that the rule for tier 3 has to identify which criterion would apply.
would not apply.
Would not, right, would not. I want to be fine, it's fine. She would not, okay, so. Yeah, I was gonna say, you could,
Yeah, you can.
okay, I'm intuitively, I think of it as the inverse of that, but I mean, I suppose either way works.
Yeah, and Ellen was the drafter of this language as well, so that's a question for her. I don't see why I think about the other.
Sure.
Yeah.
Right. And
Yeah, but this is like, so what this says is, in the tier 3 rule, the LURB would say. Impact on schools is not required for review for this permit, and here's why. Yeah.
Right, they'd have to explain it, I imagine there'd have to be some fleshing out of specific kinds of situations.
Sure.
Yeah.
Yeah.
Okay.
Yeah.
Thank you.
I mean, I also don't see why under this language they couldn't say. Development between, development of units of housing less than 5 in tier 3 don't meet these criteria. These to be reviewed, but development of units more than X do, right? The point is, we think they should have discretion and not every single type of development should be required to have a full activity permit review. Especially if we're not gonna include things like, especially if we are including things like utilities or road improvements, municipal road improvements. Like, do we need archaeological review on a rockland ditch for stormwater management that is 50 feet? 1 to 50 feet from the side of an existing municipal road? Probably not. I think the LURB also thinks probably not, so they should have the clear discretion in the law is what we support. You heard compelling testimony, which I won't repeat, from the chamber and from the commissioner. We also support all of the temporary exemptions being extended to 2030. We're not bringing forward the PHP change, but have no opposition to what either the administration or the chamber put forward regarding PHPs and non-1
PHP is priority housing.
priority housing.
Yeah,
It's
that's okay.
20,
Oh, that's right, I forgot to get it.
is it 50% affordable, 75%?
20% of units would be affordable.
20% of the units are affordable at a low AMI, I think it's 80% AMI.
Okay.
Is the old definition.
80 parental and 20 commercial.
15 years.
Yes.
Yeah, so that's like not our idea, but see no reason to oppose it. The PHP worked well for many years statewide prior to Act 181. But yeah, extends to 2030, it provides certainty for builders and property owners. It is aligned with the state's already adopted housing goal, which is set in for 2030. And I included a map here of Colchester because they are a community in Chittenden County with eligible FLU. So their FLUs are 1B eligible. And they have decided not to opt in to 1B. And so the minute any exemption goes away, then there is no housing exemptions for Act 250 in the community of Colchester. So that's my point, if you, to align the housing exemptions, which are working, they're working really well, they're producing a lot of housing. We have not gotten complaints from municipalities about the temporary exemptions. If you push them out to 2030, that allows the sort of maximum opportunity statewide in these dense, already developed areas serviced by water and sewer. For as much housing as possible to happen before 2030, at which point Colchester will not be 1B and there will not be Act 250 exemptions for housing and other communities around 8-ish for now that have made that decision. So I am not suggesting a change to section 2, which is the section that addresses Act 250 permit enforcement in Tier 1A. But I thought it would be of value to share with the committee what we heard from municipal planners in Tier 1A. So I asked a number of them to review the language in S325. And there's really 2 categories of communities that would be affected by this language in different ways. One is a community that has Act 250 permitted projects actively in construction or expected to be in redevelopment in the near term. That's like category A. Category B is a Tier 1A community that has Act 250 permitted development not expected to be redeveloped. Like it's been built, it's being used for its intended purpose, and it's expected to be that way for a long time. So the language that you have, the 1A communities, which arguably are maybe the more important to consider, said it's good or it's great. That was their feedback. The communities in category B that are not expecting currently permitted Act 250 developments to go through a redevelopment process, they were like, well, maybe there's a reason, maybe there are Act 250 permit conditions. It could be true that there's an Act 250 permit condition that we want to be enforced. And should there be additional language to clarify how that happens? But then they said, but maybe it doesn't matter because our municipal zoning is still in effect, we can still enforce our municipal permit. So if there's a permit condition that like the parking lot can only be used till midnight or whatever, they could still enforce their municipal permit regardless of what the state is doing in terms of enforcement.
What about giving them the option to give them up, say they may?
One person did say may.
Okay.
Yeah.
Then a town could hold on to the ones they want to enforce, and then they could send the ones they don't want, Hitler.
Yeah.
I don't know.
Would like
that, but
I didn't do that suggestion because one person said it and I'm like, one minority, but one planner who's great and very smart did suggest. Yeah. Yeah.
With the great, very smart plan.
Yeah.
Whoever that is.
So sorry, any questions about that? I know it's like weird. You've heard a lot about it, you've heard a lot of things I think about this provision. So we do this is the number one concern of Tier 1 communities. Yeah. Basically the same suggestions. We also suggest moving I put add 1A, but I was like, why didn't I just think of all municipal permits? So I can happily agree, make it, municipal appeals report. And we agree that the oversight should be in DHCD. They are our municipal planning partners that are a subdivision of state government. Like that's where the planning support, the municipal planning grants, and the experts who support citizen planners in municipalities are, they're in DHCD. We agreed to add Let's Build Homes, which has some policy expertise in this area. Also suggest including the Land Access Opportunity Board. They have been included in most of the most, if not all, of the Act 181 reports and stakeholder groups so far are definitely qualified and would add a different perspective that's important. And we would like to see the we would like to see clear direction, that this is not to just study appeals, how many there are, what the content of an appeal is, how long it takes, what it costs to do it. Our members feel they know that information and we don't need to see another report about it. We would like explicit legislative direction that this report is to consider and potentially make recommendations related to permitting approvals, administrative permits, and other types of housing by right opportunities. Such as form-based code, such as model code. I mean, I don't know if you. Basically saying administrative permitting is like the topic. Underneath that is model code. Form-based code. Pre-approved architectural designs. That's like the flow chart, so that's why we suggest that.
Yeah, I was wondering, because you mentioned this earlier, and I was thinking about this, does housing by right need like pre-approved housing? And if that might be a better.
Housing by right means a couple things.
Yeah. What
It's,
do you
yeah,
mean?
and it means different things, particularly in different states. Because in most states, there is no statewide permitting regime.
Mhm.
Right, and so in Montana, they have a lot of municipal preemptions. That say you can or you cannot allow this type of development or that. And so Montana almost creates housing by right or development by right in its preemption.
Mhm.
That's like one, and then there's administrative permits where you're removing the discretion of the appropriate municipal panel, which in Vermont is most often the DRB, the Design Review Board. So an administrative permit basically says, this permit application meets in an objective way the requirements of the municipality. So the permit is approved, and it's like a professional zoning administrator that looks at the permit, looks at the requirement of the local law, issues the permit. Then you can say, in that case, that it's an administrative permit, it has met the objective standard of law. It is not appealable. So if you just do the first part, if you just say this is an administrative non-discretionary decision, there was no discussion in open meeting, there was no back and forth, there were no changes to the design. It met the requirement, it was approved, that already eliminates the vast number of appeals. Burlington has adopted form-based code, basically what they do for just their downtown. They have not had an appeal filed since 2017. So South Burlington did the same thing. They have had a few, including one really painful, many hundreds day appeal. So it's not perfect, but a lot of the problem goes away. If you say additionally through the state's authority, in these circumstances, it's not appealable at all, then of course the municipal appeal goes away 100%. There's no opportunity to appeal it. And what we mean by like objective and not subjective. Right now, zoning might say something like the siding of the building must be a natural material in keeping with the other buildings in a 2-block radius. What an objective code would say, here are the 11 types of material you may side your building with. And so then the zoning administrator is like, well, this one says cedar shingle. Cedar shingle, check. Okay, they met that standard. So that's what we mean by that.
Yeah. I mean, is the term housing by right in statute, or is it just?
Not in the statute. Yeah.
There's the by right provision in the Home Act.
Oh, yes, so that's correct, and so we do use word permitted use or by right. However, the way that the home act language is written, a municipality can apply code. Setback, roof pitch, number of egresses. But they have the permanent. Yeah,
If it says you get 9, you get 9, can't get whittled down,
yeah,
keep things happy.
I mean, if I recall, the by right part of that was duplexing by right, and then there was like a quadplexing aspect as well.
Because I think I searched for the term duplex by right in statute and come up.
Oh,
So I
really?
don't- Well, I don't know.
what it says is that everywhere that in
Oh, sure.
year-round residential development. Is allowed and single family residents are allowed, then a duplex must also be allowed.
Okay, so it doesn't use the term, but that's why.
It's not permitted use.
Yeah,
Version
Yeah.
of that.
yeah.
Great.
Do you wanna see in the FLU slide?
Well, we only have a few more minutes, and I'd
Okay.
love to have like a little conversation with the committee before, but thank you so much.
Thank you so much.
Yeah.
Thank you again for taking the time. Really important.
Yeah, absolutely. So, as I expressed as we were talking through this, I have not yet seen the recommended language changes from the land use review board, but with, I just wanted to check with you all, when we get those suggestions, my instinct is to get a new draft that has those changes that I think are a little bit more up to date. And then people can be reacting to that, or thoughts.
Well, I was thinking, I mean, there are a few things that we just heard testimony on that are different than what the LURB is recommending, so.
Want to leave those out?
I guess I would. Like to maybe go through the draft with Ellen and the LURB's suggestions and the suggestions we heard from others and. Do kind of like what we did this morning with the Fish and Lake Boats bill, where we all sort of talk about
What we want to do.
what we wanna do.
That's fair. There's and I feel like there's enough agreement about most of the things.
Yeah.
So that feels doable. There's the dates. Especially as we heard, has some discussion is supposed to be had. I just want to make sure that, actually, I'm thinking about the time. That we should ask somebody to make a timeline.
Yeah, I mean,
No,
that would be helpful, a
yeah.
timeline, but also just as we're trying to figure out the dates. It seems like there's some coalescing on the dates, but there were some differences that we heard today, and I asked about a few of them. So I guess I would want clarity on where everybody is on the dates.
Right, like how aligned are people on the dates?
Yeah,
Yeah. That seems fair.
and maybe we just have this conversation with Ellen and obviously all these folks will be in for.
Yes,
Be like,
yes.
wait, what did you?
Right.
It's gotta be draft with the existing date, we'll went through the blank.
The blank.
The blank and figure out.
Sure.
Yeah.
Yeah, that could be good. Okay, so that's helpful, just thinking about planning for next week.
Weekend.
Right, yes.
She's like, we
Yeah,
can't
yeah. Yeah, right. So one of the things that we'll prioritize there is having Ellen in to go through new draft with at least the majority. What I'm hearing is some of the.
I'm wondering if tomorrow, I mean, we have that Ellen coming in to do that Act 181 continued, and maybe we do this with her instead.
Dead.
Because
You could. I suppose that depends on what's the desire of the committee in terms of, knowing what is the underlying bill. We can always do the underlying bill later too.
well. I mean, we already did some of it, I'm just wondering how much. What would be at this point versus just going through this with her and marking it up and talking about it.
Mhm. I mean, as in terms of efficiency, I'm game for that. You are as well. Do you have thoughts on this?
No, I'm happy to go either way, but
Okay.
we wanna make sure we have time.
Exactly, that's what I'm
Yes.
thinking, is having time, and
Well, and one of the things that I would, oh, sorry, go.
as long as I can, I mean, ask all the questions,
Yeah.
that I always ask.
One of the things that I would flag about this draft, I feel like, it feels like there's been a few things that people have brought up that are like, that feel like there is some consistency around, that are not in this draft. So
Yeah.
as we go through, we want to make sure that we remember what those things are.
Yeah,
But then there's like, the suggestions from Charlie Baker are, they're substantial and they're not in this draft.
right.
So- Those from, VAPTA.
Yeah.
RPCs.
Yeah.
So. It may be that. We can talk through what's here. And get a sense of what we wanna do, there's a few pieces that maybe we'll remember that are not here that we wanna add, and then I think. Looking at Charlie's suggestions, perhaps later might, because there's a lot there.
Yeah, I mean, if, it just seems like we have enough stuff
Mhm.
that we should get another draft, but I'd rather it be us talking about it
Yeah.
rather than just putting the LURPS language in.
Sure.
And then we can say, oh, we need to hear from this person, like, get a tiny bit of testimony on rare, that kind of thing. And just that we're being reminded of what everybody,
Mhm.
What can you
What do we get from Charlie? So,
I have a lot.
I know, but I mean, saying something,
because the one person having over,
I
posted on the page.
believe he sent,
It must be.
language changes, and I don't.
I feel like I need a chart of what did the LCT say, what did
Right.
VAPTA say, what did the chamber say, what did the department say.
Yeah, right, yes, for comparison, sorry, what were you saying?
well, I agree, you need to charge by
Yeah,
agency, what they said.
But we can take care of it with them all in the room.
yeah, I think it'll be okay.
You all sit where I can see you come from.
My favorite seat is. Your face is so tiny.
Okay, and then actually, I think we could also ask Ellen to come up with a timeline, potentially. I'm just thinking about like, who can we ask to? to make
Yeah,
the
well,
timeline?
somebody said there is a timeline,
Oh,
somebody did.
yes, go ahead.
The land use review board has a timeline of everything that they were asked to do in 181 and when everything is due.
Okay, so that would be
And then it
helpful to
goes into
sort of
the-
have it and execute what is the proposed timeline and how are we shifting things.
I mean, it includes everything, so you've got the wood products and lots of stuff in there.
Eight C, wait, what?
AC is.
Is that another
No,
tier?
well, we did,
No.
we did that with ACs, that's.
Decided somebody tell me about that.
It's not.
It's a good question.
Yeah.
Oh, it's a question, okay.
Yeah,
So,
so together. Anyway, oh yeah,
So they,
okay,
okay,
there's
Maybe
something,
it's on their website.
well, I
maybe they
do
gave it to us.
need to chat with Ellen today anyway, so I'm open to switching the agenda or the plan for tomorrow to, instead of it being a review of Act 181. Starting to dig into some of this language and.
Yeah.
That sounds great. Any other thoughts folks have about?
that's what we should do is have in front of us for that discussion. Stuff from Charlie, stuff from today,
Mhm.
stuff all
And the LURP.
in, yeah, order of.
Well, if we could get language suggestions specifically, I mean, I've written so many notes.
Ask them all to have a representative in the room. I mean, I know you guys could be here, but like, there's nobody here from the LURP right now, right?
Right, we can ask.
And nobody here from VAPTA.
There's nobody here from VAPTA.
So, then they should us to speak for that, let's see.
Yeah.
We'll get, find all approved house.
Okay,
Sounds like fun.
my guess is that we won't get through all of
Probably not.
But we'll do what we can tomorrow.